In 1947, a woman, Miss Stone, was standing outside her house on Cheetham Hill Road, opposite Cheetham Hill Cricket Club, when she was struck by a cricket ball. The ball had been hit by a batsman from the visiting team and had travelled about 90 metres. The club was founded in 1864, 46 years before the road Miss Stone's house was on was built. The pitch was surrounded by a 7-foot high fence, and the pitch itself was 10 feet below the level, making the fence 17 foot on the pitch side. Miss Stone brought an action in nuisance and negligence against the cricket club, which was quickly dismissed, as there was evidence that the cricket ball had only travelled that far from the ground 6 times in the previous 38 years, and as no other injury was recorded in that time, there was no negligence, and it was ruled that a single instance of a ball leaving the ground could not be seen as nuisance. The Court of Appeal heard the case in 1949. The case for nuisance was dismissed on the same grounds, but 2 of the 3 judges who heard the case held that an accident of this sort required explanation, and that the defendants, being aware of the potential risk, were negligent when the maximum of res ipsa loquitur was applied. In 1951, the case came before the House of Lords. The verdict, though close, based on whether a reasonable person could have foreseen this as anything more than an extremely remote accident, was unanimous, and found there was no negligence. The Lords agreed that the risk was just too remote for a reasonable person to have foreseen, although it was pointed out that hitting the ball out of the ground was an objective that the batsman would be trying hard to bring about. The Lords also believed that there were implications in terms of what liability would have meant in creating restrictions in what we can do in our everyday lives in an urban modern society.